Dear chairpersons, distinguished state representatives, thank you very much for giving me the opportunity to speak to you. Please allow me to focus only on some major aspects of international law which are part of the bigger picture of international affairs. It remains undisputed that Nagorno-Karabakh is part of the territory of Azerbaijan and that therefore Azerbaijan has jurisdiction over this territory, including the individuals living there. However, Azerbaijan's sovereign rights apply only within the standards of international law, that is, treaty and customary law. In context with Nagorno-Karabakh, there is no legal justification allowing Azerbaijan to ignore its obligations from international law. So, what are these obligations more specifically? As a consequence of international treaty law, states have to comply with decisions of international courts whose jurisdiction they have accepted. Two international courts have jurisdiction with respect to Nagorno-Karabakh and the right to make decisions binding upon Azerbaijan. The European Court of Human Rights, based on the European Convention on Human Rights, and the International Court of Justice, based on particular treaty law, here the International Convention on the Elimination of All Forms of Racial Discrimination. The European Court of Human Rights ordered interim measures on 21 December 2022 that Azerbaijan has to take all measures that are within their jurisdiction to ensure safe passage through the Lachin corridor. The International Court of Justice ordered, very similarly, provisional measures on 22nd of February 2023 and reaffirmed them on the 6th of July 2023. I quote, "The Republic of Azerbaijan shall take all measures in its disposal to ensure unimpeded movement of persons, vehicles, and cargo along the Lachin corridor in both directions." In the meantime, most individuals of the ethnic Armenian population of Nagorno-Karabakh have left the territory and entered Armenia via the Lachin corridor. However, based on the information available, neither the supply of goods nor the passage of persons from Armenia back to Nagorno-Karabakh was and is assured by Azerbaijan. Thus, Azerbaijan does not comply, at least, with the in both direction requirement. These court decisions refer to the rights of the ethnic Armenian population of Nagorno-Karabakh. They are collectively protective under international law by the principle of equal rights and self-determination of peoples. In addition, the Council of Europe Framework Convention for the Protection of National Minorities specifies certain rights in this context. Azerbaijan is a party to this treaty. The right of self-determination, as designated today, includes, to a certain degree, autonomous rights of independent organization within the legal order of the state having jurisdiction, that is, Azerbaijan. However, self-determination under international law does not imply a right to forceful secession or complete sovereignty. But this has not been seriously claimed either. Moreover, individuals of the ethnic Armenian population of Nagorno-Karabakh are protected by international human rights law as well as international humanitarian law. With respect to the ethnic Armenian population, international human rights law appears to be one of the most relevant legal areas, in particular, the European Convention on Human Rights. I will address this issue very briefly. Article 2 of the European Convention on Human Rights, the right to life. Article 3, prohibition of torture, inhuman and degrading treatment. Article 6, the right to a fair trial. And Article 8, the right to respect for private and family life, are most important with respect to the situation around the Lachin corridor. As long as the Lachin corridor was blocked by Azerbaijan, the population of Nagorno-Karabakh could not be supplied with food, medicine, energy, etc. This endangered many individual lives and was an inhuman treatment. Thus, Azerbaijan violated Article 2 and Article 3 of the Convention. Since there was no way to judicial review of the situation. Article 6 was also violated. Finally, as long as individuals from Nagorno-Karabakh could not pass the border to Armenia to visit their family members, Article 8 was violated in addition. Besides human rights law, aspects of international criminal law could also be relevant. By now, it at least cannot be excluded that several offenses of war crimes and crimes against humanity have been committed by individuals from Azerbaijan. However, jurisdiction on these crimes is a different matter, and additionally, the crime of genocide, the crime of crimes, is a different matter too. Genocide is a particular international crime confirmed by the 1948 UN Genocide Convention, as well as by codifications of international criminal law, such as the Statute of the International Criminal Court. The duty to prevent genocide under Article 1 of the Genocide Convention addresses every state in the world and has the status of jus cogens. Moreover, Armenia and Azerbaijan are both parties to the Genocide Convention. The elements of genocide and related acts are listed in Articles 2 and 3 of the Genocide Convention. The ethnic Armenian population of Nagorno-Karabakh is an ethnic group and thus protected by Article 2 of the Genocide Convention. With regard to the Latin corridor, only Article 2c of the Genocide Convention may be pertinent. The Actus Reus says, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. However, the fact that the Armenian population of Nagorno-Karabakh could use the Latin corridor in order to escape to Armenia is a strong indicator against the characteristic calculated to bring about the physical destruction in whole or in part. This is only in terms of genocide, I have to stress. The group of the Armenian populations thus was not subject to physical destruction, but to social destruction by forced relocation. However, acts of so-called ethnic cleansing as such are not covered by the Genocide Convention and the crime of genocide. Another argument against genocide in this context is a genocide-related element of mens rea. This is the specific genocidal, I quote, intent to destroy a group in whole or in part. It is rather unlikely that actors from Azerbaijan intended to destroy the Armenian population of Nagorno-Karabakh, since these were merely subject to relocation. Please don't get me wrong, this is only in terms of genocide. So what can be concluded from all that in terms of international law in general? First, Azerbaijan continues to violate its specific international law obligation to ensure free passage through the Latin corridor in both directions. This runs parallel with the violation of the more general right of self-determination. Second, as a result of this violation, Azerbaijan is responsible for human rights violations against individuals of the Armenian population of Nagorno-Karabakh under Articles 2, 3, 6, and 8 of the European Convention on Human Rights. Third, aspects of international criminal law need to be further assessed. Fourth, genocide has rather not been committed against the Armenian population of Nagorno-Karabakh. After all, the lens that focuses international law is not crystal clear, but clear enough to determine that Azerbaijan is responsible for several serious violations of international law. They all have in common that the Latin corridor is not kept open in both directions to safeguard collective and individual rights of the Armenian population of Nagorno-Karabakh. Thank you very much for your kind attention.
Thank you, Dr. Schiefbauer. Thank you for providing us with your legal analysis. Adesso lascio la parola all'onorevole Piero